Good morning, everybody. The time is now 10 o'clock and the meeting is called to order. Mr. Troman, is anyone signed up for public comment?
No, sir.
Great. I'll turn the meeting over to Commissioner Conant to preside over agenda items 3 through 8. Commissioner Conant.
Well, thank you, Chairman, and good morning, Ms. Miller.
Good
I
morning.
understand that we have a case to consider under agenda item 3. Is that correct?
Yes, sir. Commission Appeals is requesting a letter of continuing jurisdiction in case number 3800446. This case was voted on docket 38A on October 21st, 2025. The commission voted to deem the claimant's appeal timely and to affirm the ineligibility, Labor Commissioner dissenting. A decision was mailed on October 23rd, 2025. The appeal deadline is November 6, 2025, and there is no indication of any appeal filed. The summary circulated to the commissioners prior to that vote failed to note that the determination on appeal had been reversed at the determination level, and Commission Appeals is requesting a letter of continuing jurisdiction so that full procedural information may be considered by the commission. Commissioner Trevino.
I agree.
And Chairman Esparza.
I also agree.
And Commissioner Conant.
I agree.
Thank you.
We will now consider tax liability cases under agenda item 4. Is it correct that we have no tax cases on docket 45?
Correct. No cases.
Very good. And I understand we have no fair housing cases under agenda item 5. Is that also correct?
Yes, sir. Correct.
We will now move to agenda item 6. We have no child labor cases on docket 45.
Correct. No cases.
We will turn to consideration of wage claim cases under agenda item 7. We have no wage claim cases pulled for additional discussion on docket 45. Is that correct?
That's correct. No cases pulled for additional discussion, but you should have received the wage claim short form dissent list for docket 45.
I move that we accept staff recommendations on the wage claim cases on docket 45.
I second the motion except for those cases which I am dissenting as reflected on wage claim short form dissent list for docket 45.
I concur with the commissioner's motion, except for the cases which I am dissenting is reflected in wage claim short form dissent list for docket 45.
And the motion passes with the exceptions noted. We move now to agenda item 8 and consideration of unemployment insurance cases on docket 45. Please proceed. Thank you.
Case number 3410000, Commissioner Trevino.
The decision is not supportable. The claimant quit to accept another job that then did not materialize, which would normally not be a qualifying separation. However, the claimant had been qualified for benefits following the filing of the initial claim and had worked for the named employer for less than 4 weeks. Additionally, while the work for the employer met the claimant's wage demand, it was a temporary job and therefore should not be considered suitable work. The claimant resigned this temporary work to accept a permanent position that paid a significantly higher hourly wage. Since the claimant was receiving benefits, worked for the employer for less than 4 weeks, and this job was not suitable work, the claimant had good cause connected with the work for quitting under section 207.045 G1. Reverse the AT, no voluntary leaving, no overpayment.
We should affirm the AT decision. The claimant quit to accept further work which did not materialize. Since the claimant quit when continued work was available, his separation was voluntary and without good cause connected with the work. Finally, section 207.045 G1 does not apply because the claimant's working conditions were not intolerable or otherwise unsuitable. As such, we should affirm the AT decision, voluntary leaving, overpayment.
Affirm the AT, voluntary leaving, and overpayment. The claimant quit without good cause because he resigned to pursue other work that did not materialize. Relevant sections of the Act could possibly qualify the claimant, such as 207.045 G, G1, and H, but those sections do not apply to this case.
Short form dissent, ma'am.
Yes, sir. Thank you.
Case number 3668282, Chairman Esparza.
The AT decision should be reversed. The claimant was involved in an altercation with other coworkers. Claimant concedes she used force to push an office door open, and during this altercation, a coworker of the claimant was on the other side of the door. The employer has a zero tolerance policy on aggression and violence in the workplace. As such, the claimant's behavior constitutes misconduct, and we should reverse the AT decision. So misconduct, reimbursing employer not billed, adequate employer response.
The AT decision is correct. The employer discharged the claimant due to her involvement in a confrontation with several other employees. The employer only provided secondhand evidence of the incident, alleging that the claimant acted in an aggressive manner and that she escalated the situation. The claimant provided sworn firsthand testimony denying the employer's allegation that she raised her voice, and she also testified that she attempted to defuse the situation. Therefore, the employer has failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
Concur with Commissioner Trevino in his vote. The employer has not met their burden of proof since they offered only secondhand testimony that the claimant was the aggressor, while the claimant offered a firsthand denial.
Short form dissent.
Yes, sir.
Case number 3671510, Chairman Esparza.
We should reverse the AT decision. The claimant was terminated for failing to meet the employer's job standards. Despite evidence which demonstrated satisfactory performance during the initial months of employment, her performance subsequently declined, concurrent with documented issues of punctuality and excessive cell phone usage during work hours. Since the claimant's performance deficiencies arose from her disregard for assigned job duties, her actions constituted mismanagement of her position of employment, arising to misconduct connected with the work. As such, we should reverse the AT decision. Misconduct, no chargeback, adequate employer response.
The decision is correct. The claimant was discharged due to her inability to meet the employer's performance expectations during her short period of employment. The complainant performed her job to the best of her ability and provided credible firsthand testimony that she requested additional training on several occasions, but the employer refused to accommodate her request for help. Since the employer failed to establish that the claimant was ever able to meet their performance expectations, her inability to perform the work to the employer's satisfaction did not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Concur with Chairman Esparza in both vote and rationale. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3698756, Chairman Esparza.
We should modify the AT decision. First, I don't contest the claimant's appeal was timely. Concerning the job separation, the claimant resigned once she was informed of the requirement to report to the office. Although the claimant was hired for an in-person position when she was requested to come in due to performance delinquencies, she quit alleging personal reasons unrelated to work. Since the claimant quit when continuing work was available, her separation was voluntary and without good cause connected with work. As such, we should modify the AT decision. Timely claimant appeal, voluntary leaving, no chargeback.
The AT decision is not supportable. By signing up to receive electronic correspondence from the commission within the appeal window, the claimant perfected a timely appeal to the initial determination. As to the job separation, the employer arranged for the claimant to work from home in January of 2023, following her maternity leave. The claimant had worked from home for nearly a year when the employer suddenly required her to return to the office with no advance notice. The claimant was forced to resign because she did not have immediate childcare arrangements and transportation available to report to the office. Therefore, since the employer made a substantial change to the claimant's working arrangement, she had good cause connected with the work to quit. Reverse the AT, timely claimant appeal, no voluntary leaving, chargeback.
Modify the AT, timely appeal, voluntary leaving, no chargeback. In this case, the weight of the evidence suggests that the claimant was on notice that she could be called back to the office since she was hired for an in-office position, and that she quit before allowing the employer an opportunity to offer accommodations. As such, she voluntarily quit without good cause.
Short form dissent, ma'am.
Yes, sir.
Case number 3703204, Commissioner Trevino.
The decision should be modified. The claimant had repeatedly reported to the employer that technical issues were causing her computer not to log calls, which resulted in appearing that she was idle. The claimant's manager had already investigated this once before and had to apologize to the claimant because the technical problems were causing the issues. Despite this, the manager then investigated the matter again a couple of weeks later. The claimant repeated that all the discrepancies were being caused by the same technical problems that she had been reporting. The employer then discharged the claimant for what they considered refusing to cooperate with the investigation. Under these circumstances, and without the employer proving any testimony to support their allegations, the employer did not meet their burden of proving that the claimant engaged in work-connected misconduct. Modify the AT, valid claim, no misconduct, chargeback.
The AT decision should be affirmed. First, I don't contest the claim was valid. Concerning the merits, the claimant was discharged after she was being uncooperative in an integrity investigation regarding her assignments. This impeded the employer's investigation and was a mismanagement of her position of employment. As such, the claimant's actions constituted misconduct, and we should affirm the AT decision as a valid claim, misconduct, no chargeback.
Concur with Chairman Esparza in both vote and rationale.
Thank you.
Short form dissent.
Yes, sir.
Case number 3721891, Chairman Esparza.
The AT's decision should be reversed. Concerning the good cause, the employer testified that its city conducted changes to addresses, specifically the address of the business, leading to a delay in the employer receiving the AT hearing packet. Since the employer did not receive the AT hearing packet until after the time of the scheduled hearing, the employer established a good cause. As a job separation, the claimant failed to show up to the employer's place of business on the final date of employment. As such, the claimant's behavior constitutes voluntary leaving, and we should reverse the AT decision. The employer established good cause for missing the AT hearing, voluntary leaving, no chargeback, adequate employer response.
The AT decision should be affirmed. Regarding the good cause issue, the employer testified it did not receive the hearing notice until after the AT1 hearing, but admitted they did not change their address with TWC as required, and the delayed delivery was caused by forwarding the mail to the new address. Therefore, the employer was not prevented from participating in the hearing by circumstances beyond its control, and has failed to establish good cause for its failure to appear at AT1. Regarding the merits, the available record established that the claimant's hours were reduced because the work was slow. Therefore, the claimant was partially laid off due to lack of work. Affirm the AT, employer failed to establish good cause for AT1, no misconduct, chargeback.
Modify
I'm
the
sorry.
AT.
Yes, sir.
Good cause, resubmit. The employer provided credible testimony of untimely receipt of the hearing notice caused by the city reconfiguring the streets and its mail delivery being delayed, factors outside of the employer's control. This testimony, along with the employer's timely filing of a petition to reopen, establishes good cause for its non-appearance.
Yes, sir. We have a majority vote that there is good cause, not a majority vote on what to do with the merits.
I'll support Commissioner Connett on a resubmit.
We will resubmit the case. Thank you, gentlemen.
Thank you.
Case number 3739263, Chairman Esparza.
We should reverse the AT decision. Concerning good cause, the employer provided credible testimony that they received the AT hearing packet on the day of the scheduled hearing. Receiving the hearing packet on the date of the hearing severely impacted the employer's ability to adequately prepare for the hearing. Since the employer was not afforded sufficient time nor the opportunity to prepare for the AT hearing, we should find that the employer established good cause for missing the AT hearing and resubmit the case for merits testimony. Reverse the AT decision. The employer established good cause for missing the AT hearing and resubmit.
The decision is correct. The employer did not have good cause for failing to appear at the AT1 hearing since the employer's representative called in late because they lost track of time. This was a circumstance that was within the employer's control, and therefore the employer has failed to establish that they had good cause for missing AT1. Regarding the work separation, the available evidence indicates that the claimant was discharged due to a disagreement that occurred with another employee. The claimant denied the employer's allegations and the employer did not provide any direct evidence regarding the claimant's actions during the final incident or whether she had any prior warnings. Therefore, the employer failed to prove that the claimant was discharged for misconduct connected with the work. Affirm the AT, employer did not establish good cause for AT1, no misconduct.
Modify the AT, good cause, resubmit. Because the employer's testimony of their routine establishes that they did not receive the notice until the day of the hearing, and because they called in only 6 minutes late, the employer has established that they made a good faith effort to attend the hearing. As such, we should grant good cause and resubmit the case for merits.
We will resubmit the case.
Case number 3745890, Chairman Esparza.
We should rehear this case. The employer maintained a zero tolerance policy on harassment. Claimant was terminated when he acted unprofessionally toward a subordinate. And although the claimant denied his actions, the record suggests that the employer possessed video evidence of the final incident, which could prove beneficial to the analysis of the job separation. Since commission should review the employer's additional evidence prior to rendering a decision, we should rehear this case to obtain and review the employer's additional evidence. Rehear.
The decision should be modified. I don't dispute that the employer established good cause for missing AT1. However, regarding the job separation, the employer only provided vague hearsay testimony in support of their allegations that the claimant made inappropriate comments to a subordinate employee. The claimant, on the other hand, has consistently denied that he acted inappropriately towards the other employee. Since the claimant's sworn denial of the allegations outweighs the employer's vague secondhand evidence, the employer did not meet its burden of proving that the claimant was discharged for misconduct connected with the work. Modify the AT, employer had good cause for AT1, no misconduct, bill reimbursing employer, void adequate response.
Modify the AT, good cause, and rehear for the employer to offer firsthand testimony and or evidence of the alleged inappropriate behavior.
We have a majority vote on good cause, and we will rehear the case on the merits.
Case number 3762391, Commissioner Trevino.
The AT decision is not supportable. The weight of the evidence did not establish that the claimant voluntarily quit. Both parties agree that the claimant was locked out of his computer and then was brought in and informed that his position was no longer going to be available because the employer was replacing him. Both parties also agree that the claimant was not given any indication that he would be offered a different position. Therefore, the employer initiated the job separation when the claimant was given a reasonable impression that he was being discharged, and any statements that the claimant may have made later about stating that starting his own business did not change the nature of the job separation. The employer failed to provide sufficient evidence to establish that the claimant was discharged for any reasons that would constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be modified. The claimant gave the employer a reasonable impression that he intended to resign from his position during a meeting. Claimant and the employer then exchanged emails to confirm the details of the claimant's job position, where the claimant consented to the changes in his job, including a resignation date. As such, the claimant's departure from the job constitutes voluntary leaving, and we should modify the AT decision, voluntary leaving, no chargeback, sever adequate employer response.
Concur with Chairman Esparza in both vote and analysis.
Short form dissent, ma'am.
Yes, sir. And that was the last case pulled for additional discussion on docket 45. You should have received the UI short form dissent list for docket 45.
I move that we accept staff recommendations on the remaining UI cases on docket 45.
I second the motion, except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 45.
I concur with the commissioner's motion, except for the cases on which I'm dissenting, as reflected in UI short form dissent list for docket 45.
And the motion passes with the exceptions noted. That concludes our business on agenda items 3 through 10. Chairman Esparza, I hand the meeting back to you.
Thank you, Commissioner Connett. That brings us to item 13. Time's now 10:19. Gonna write that down. The Texas Workforce Commission is now going into executive session of room 250B to discuss appointment, employment, and duties of executive director, internal auditor, executive staff, and other personnel pursuant to Texas Government Code 551-074A1. Commissioners? Okay, the time is now still 10:36. The commission met in executive session beginning at 10:21 and concluded at 10:36. No action is being taken. Can I get a motion to adjourn?
Chairman, I move to adjourn.
I second motion.
Motion passes and we are adjourned. Thank you very much.